thank you everyone for attending this lunchtime for the part of the webinar seminar programme we're putting on. This one today is minimising exposure to sports and company away day claims. For those in attendance who don't know me, my name's Mark Hastings. I'm a Senior Associate and a Solicitor Advocate within BTO's Insurance Law team, and I'll be presenting today's seminar. For today's purposes, lockdown's over. We've emerged, some with more speed than others, to enjoy the sunlit uplands and take back leisure pursuits that were prohibited during lockdown. A whole host of sporting activities, from ultimate frisbee, which I'll come back to paddleboarding, to the less exotic of football and golf, have all gone back onto the sporting calendar, which is a great thing. I propose today to look at some of the issues which can arise in sports claims, together with corporate away days gone awry, and offer one or two observations on the risk mitigation measures which sports clubs, regulatory bodies, employers, or basically whoever else is in control of or participating in a sporting activity. By dint of the broad spectrum of sports and away day activities that you can undertake, we're not going to have time today to undertake a deep dive into the minutiae of a particular sport or activity. The observations this afternoon that I'll offer are really to set the scene and to give you some food for thought. So that's the content of what I'm proposing to run through this afternoon. So sports claims, case studies, claims defensibility and evidence, the C word, which is not the C word you might maybe associate with me, then the perils of the away day, some more case studies and mitigation measures, and then if we have time or if anybody's interested, we can take some questions. So without further ado, can we just have the next slide, please? So the standard of care in a sporting context, or where an injury has occurred in the context of a sports game, what's the standard of care? It's probably trite to say that all sporting activities carry with it some inherent risk of injury, particularly I'm thinking of contact sports, football, rugby, hockey, where opponents engage each other as part and parcel of the game. Collisions will occur, injuries are relatively commonplace. The question is really when is a line crossed in the course of a match, tipping into conduct that's tortuous or delictual. It's also fairly obvious to say that participants in the game, together with its organisers and the officiating personnel, owe a duty of care to those participants. But the standard of care against which the conduct is tested, and whether that constitutes a breach of duty at common law, is largely going to be determined by the rules of the particular sport. In general terms, I would say the conduct has to be reckless and fall below the standard of a competent professional player. It's also conduct which goes beyond an error of judgment or timing. Now, over and above that, the risk of injury has to be reasonably foreseeable, whether that conduct is deliberate or just negligent. The test is a high one in professional claims, or where it's a professional sports person involved. It's arguably muddier, I would say, in amateur claims. To what standard are those players held? Is it the average player playing in that particular league or level? That might be a difficult issue upon which to gain objective evidence and the standard that you would be testing that player's conduct against. Next slide, please. Who's at risk? Well, it's a large question. Suffice to say, there's a range of people or bodies that are at risk here of claims being made against them. The slide that you can see shows that these range from sports clubs, academic institutions if they have a sports team, leisure clubs, and also the regulatory body for a sport, and the referees indeed who might be officiating a game. At the outset, I might think that claimants would want to cast a wide net to potentially draw in perhaps not only the participant who caused the injury or the venue within which the event was staged, but also alongside the club who organised it and ultimately the party who had control and responsibility for that game or event. The case law, which I'm going to trot through in a second, draws out the type of examples where claims from sporting activities have been made, and really the range of claims and criticisms and situations levied at particular bodies which were successful. I think it's important that we gain an understanding of that before we then can look at the measures which can be taken to mitigate against those type of claims. So if I could have the next slide, please. There's a number of cases on this slide which demonstrate a range of particular sports. And I wanted to try and give a spectrum of sports to then draw out examples of the type of conduct that was negligent and what the courts had said. So the first case is quite well known, of Tomlinson and Congleton Borough Council. That was a case involving swimming, a swimming incident that made it all the way to the House of Lords, nearly, well, close to 20 years ago. The Congleton Borough Council owned a park. Within that park, there was a disused quarry which housed, well, in the summer months, it could be quite a shallow lake. The council knew people swam in it, prominent signs had been erected, park rangers had been deployed, there was leafleting telling people, effectively till they were blue in the face, don't swim in that particular lake. Suffice to say, this pursuer or claimant dived in, sustaining life-changing injuries. He made a claim against the council, arguing that they should have prevented him from accessing the lake. The House of Lords rejected that, holding effectively that it would be very rare for an occupier to be under a duty to prevent people taking risks inherent in the activities if they freely chose to do so. If somebody wanted to climb a mountain, jump in a lake, or dive in the sea, then that was their affair, and the risk needed to be obvious and dangerous in order for the duty to prevent to even arise in the first place. So that's quite a helpful authority, I would say. The next case, I think, is also quite well known if you remember, if you're into football, of Ben Collett and Smith in Middlesbrough FC. That was a case where Collett had sustained career-ending injuries as a result of a tackle by Gary Smith. Now, that tackle met the standard, or fell below the standard of a competent professional footballer, amounting to a breach of duty. The liability in that case was admitted. Now, Mr. Collett was awarded £4.3 million back in 2008, of which £3.8 million was for a loss of future earnings. Now, you can shudder to think what that might be worth now in today's terms, given the discount rate and the increase in footballers' salaries over the last 10 to 15 years. The point really is just to demonstrate the potential value of such claims in certain circumstances, and it might be, well, maybe slightly less valuable, but the point still remains: if you were to seriously injure a high-flying professional in a game of whatever it was, rugby or football, that rendered them unable to work, you could still find yourself facing a 6 or 7 figure claim fairly easily in those circumstances. So we've looked at games involving participant injury. I mentioned previously that part of these type of claims could be against the institutions governing, the governing bodies. That happened in Vowles and Evans and others in 2003. That was another, that was a rugby incident involving a referee. So ultimately, the referee's duty, I would say, is to enforce the rules of the game for the protection of the participants. In Vowles, this came sharply into focus when the Welsh Rugby Union and its referee were sued by the claimant who was actually very seriously injured when a scrum collapsed. So what had happened in brief terms was a prop had been injured. The referee then permitted a flanker to take his place in the scrum. He didn't inquire as to the flanker's experience of playing prop, and the flanker was indeed the cause of the collapse of the scrum. The referee in that case bizarrely argued that he didn't owe a duty of care to the players. That was unsurprisingly unsuccessful, with the Court of Appeal holding really that referees are there to enforce the rules which are designed to protect the players. In that case, the claimant was successful, given the referee's breach of duty was quite egregious. Nonetheless, if you are criticising, or a referee has been criticised in one of your cases, the standard is high, or the standard of care to breach that threshold is going to be high. In a fast-moving game, referees are going to be afforded quite a bit of latitude of error for mistakes, errors of judgment. Put it like this: if they weren't, then you'd find that the football pundits would quickly find themselves out of work. The standard of care strikes me as being that of reasonable care of a competent referee, and that, from the case law, that seems to be a bit of a mash-up between a common law duty to take reasonable care and a bit of professional indemnity. What would the standard of the ordinarily competent referee be? What you can expect to see to answer those questions, perhaps for you, is expert evidence from suitably qualified professionals, together with the competition rules and the training. They might be at the forefront of a claim and its defence. The next case on the list, a completely different type of sport, if you can call motor racing a sport, is that of Wattleworth and Goodwood Racing Company Limited from 2004. That involved a driver who was killed at a track day at Goodwood. Now, the regulatory body for motorsports in the UK had made recommendations to the defendants over its crash barriers that it would require for professional events. Now, this individual was killed at a track day, not an authorised motorsport professional event. That seemed to be immaterial for the court, as it held that the risk of injury was reasonably foreseeable and an unsuitable barrier could lead to that, to those using the track, whether it was on for leisure pursuits or for professional purposes. I think that case is quite useful, as it demonstrates a wider view being taken of reasonable foreseeability of harm and the absence of taking a particular safety measure and what that might lead to. And also the reference to industry standards and guidance when assessing whether there was a breach of duty at common law. The last case which I wanted to mention to you today is that of Anderson. I'm not going to try and pronounce the French word, but against Showbiz from 2008, and it's a skiing incident. That involved a pursuer or claimant, beg your pardon, because it was in England, purchasing ski lessons. During those ski lessons, he went off-piste, quite literally, crashing into a tree and was rendered tetraplegic. Now, this particular individual on the ski package holiday had struggled in earlier off-piste sessions that week. The court held that really the instructor should have recognised that he wasn't as good at skiing as others in the group, and that the slope in question wasn't within his capabilities. Now, the claimant succeeded in Anderson. However, there was a 70-30 split in his favour, with the court holding he was 30% to blame for failing to voice his own concerns, given he was an adult. Now, it struck me as being slightly harsh. You know, he's not the ski expert. He's putting himself in the hands of a ski expert to teach him and to choose slopes that are suitable for his capabilities, yet he's still 30% to blame. Anyway, that's just my tuppence halfpenny on that one. The factors, I suppose, what I wanted to draw out more than that was what the court would look at in cases involving instruction. Well, one, whether the instructor had made an accurate assessment of the participant's ability in the activity. Two, was the slope appropriate for that, relative to that level of ability. Three, what were the instructor's qualifications? And four, once you'd done that, look then at the claimant's own actions. All of this against the backdrop of the governing body's oversight, or the rules that were in place for skiing. In the case of Anderson, what did the International Ski Federation rules say that instructors ought to have done, and engage the conduct against those rules? And that's all the case law I wanted to really look at. If I could have the next slide, please. Thank you. So clearly the issues in sports cases are going to be specific to the sport and incident in question. However, I think there's some general themes that emerge from the case law that could inform how these claims are handled and in the assessment of their defensibility. Briefly, the slide makes mention of quite a number of issues. A lot of these will be fairly obvious to you, but I think it's worth just recapping on them just to get a view on what you might need to be or want to be thinking about if you've got one of these claims on your desk or you've had a notification. Witness evidence, first and foremost, like any accident claim, the accuracy of the evidence taken contemporaneously is going to be important, and what was recorded in the aftermath. I would say the early recovery of that is going to be particularly important in amateur incidents where you might not have a contemporaneous audio or video recording of the incident, and you might have slightly competing events. And if it's a game involving numerous participants, football, for example, or rugby, you want to check for the consistency of the evidence and what the witnesses say to see if it all tallies up. Video and camera recordings are the second on the list, more likely to be available in professional claims. Perhaps it might be some of the amateur sports or events or whatever it might be recorded, but if that's not available, it makes the contemporaneous witness evidence even more important to secure. On that theme, the accident reports or delegate match reports are equally important. What was recorded contemporaneously is often revealing not only in what happened in any initial concerns, but also observations regarding the weather, the state of the playing surface, things like that can be important depending on the particular case you've got, whether it was the unsuitability of the pitch, the boots been worn, the checks made by the referee, for example. Referee opinion, going slightly further down the list, in an officiated game, particularly if you're trying to distinguish between deliberate conduct or reckless conduct. Was the offending player sent off? How did the referee judge the matter? Following down from that, expert evidence that's again linked to the referee point, although that would be objective and independent. But if the cases weren't relating to the organisation and setup of an event, or indeed a referee's performance or handling of a particular situation, then that would be important. And finally, policies and procedures. Claim dependent, I would say these can be quite important in assessing the organisation. Well, if you're acting for the body who put on the event or was responsible for its oversight or hosted the venue within which something was taking place, the organisation, training and information all feed into the setup of the events and the qualifications of those involved. Setting up, were they appropriate? Did they have the skill set to identify, manage and mitigate risk? That's got a wider import, I would say, in cases of injury in a game setting against the standards of which the offending play is judged judged, and also in cases where it's a set-up of the court, for example. I suppose the point I'm trying to make is that in claims mitigation, for your clients to be fully aware of the protocols they require to adhere to, be proactive and forward thinking in how they assess risk and how they impart information to participants in terms of what's going to happen, when it's going to happen, and also oversight on the physical setting in which the events unfold. I mentioned at the outset ultimate frisbee. It's a nonsensical game if you ask me, but I dealt with a claim involving ultimate frisbee a few years ago for an academic institution. Its risk assessment, its protocols, its governing rules were all fine. The game could be played indoors and outdoors. You're thinking, so far so good. This was played in a basketball court. The parameters were all clearly marked out. Everybody knew what they were doing. Everybody was an experienced player. However, what nobody had considered was the distance from the edge of the court to the wall, and that ultimate frisbee courts are wider and longer than basketball courts. So inevitably, a player who loses balance falls off the court into the wall, sustaining a brain injury, and the defence of that claim was compromised because it was a reasonably foreseeable risk, and it was the only reasonably foreseeable risk that hadn't really been taken into account, and it had to be that was a specific injury that was sustained by that particular claimant. If I could have the next slide, please. And that's the C word, and I don't think it's possible to do any topic now without at least mentioning the spectre of COVID. It looms over society generally in terms of the viability of sport and your participation within a particular sport. What I really did only want to touch on for today's purposes was COVID protocols. In professional sport, they look to have been ironed out last year, particularly for football, and there's UK government guidance for elite sport. However, for amateur sport, it's not always clear how robust those would be, and to avoid being wise after the fact for any brokers or relationship managers listening, it would be worth revisiting those with your clients to check that they reflect current practice, they reflect the regulatory body's guidance, and that the rules are being implemented as well as having them on paper. Are they being put into practice for participants and observers alike for that particular sport? The reason I raise that is because it's not clear to me how the courts are going to approach causation in COVID claims. Are they going to use the but-for test, given it's an airborne disease? The claimant's going to have to establish that it was your insured negligence that was the likely cause of what might be a number of competing options. But what about if they relax the rules on causation and we go back to the material contribution test that you would see more in clinical negligence or disease claims, where there's a negligent and non-negligent exposure, and if you can prove that the negligent exposure made a contribution, then that gets you over the line on causation. It's difficult to say where it would go with that because COVID seems to be contracted by a single exposure, so arguably, are you going to get into the material contribution test? Hopefully not. Nonetheless, to avoid getting into these arguments in the first place, it's well worthwhile having robust COVID-19 protocols in the first place to prevent infection as far as you can, or at least being able to rebut any proposition that it came from your clients in the context of the particular event that they were hosting or participating in. So that's all I wanted to say on sports claims. It's been a bit of a whistle-stop tour, given the time we have available today. I wanted to move on to corporate away days. Now, everyone enjoys them, don't they? It's a chance to bond with those lovely people that you spend the rest of the year studiously avoiding. The orienteering exercise through the wet countryside in the mud, followed by the meal sitting beside someone you've got no idea who they are, is not to be sniffed at. In truth, I probably think it's more the lure of free alcohol that draws a lot of flies to the proverbial fire for these things. However, for today's purposes, what about when it goes wrong and somebody gets hurt? Unsurprisingly, that's happened in numerous instances in the past. However, it's not an area that's particularly densely populated by reported decisions. If I could have the next slide, please. You'll see the 2 points I've identified on the slide, which I'm going to touch on. The first point is whether attending an away day, which might be voluntary, but which really attendance is tacitly compulsory, whether that constitutes being at work. I would say the case law is probably inconclusive on that. My own view is that it's very case specific, and it really depends on a number of factors, and making it difficult to fix a general principle that's of a wider application. Even if it's not designed or determined to be at work or reasonably incidental to your employment, the courts have recognised that's not necessarily the end of the matter for the business that's your employer. They can still owe a duty of care to employees attending a company away day, with the argument being the extent of that duty and breach of that duty. If I could have the next slide, please, Marianne. There's really two cases I wanted to touch on with you, Reynolds and Strutton Parker LLP 2011 and Grant against Fife Council and another from 2013. The first case is an English authority, the second case is a Scottish authority. If I've got time, I'll touch on Bellman, which isn't a sports-related claim, but it's got a point about vicarious liability that's quite interesting. So, if I could have the next slide, please. Reynolds is an interesting one. It concerned a collision between two colleagues who were participating in a cycling race and a team bonding exercise organised by a firm of chartered surveyors. The incident occurred effectively due to the pursuer or claimant failing to allow his colleague to pass him on approach to the finish line in the expectation that his colleague would brake. He didn't. A collision occurred. The colleague was wearing a helmet. The claimant didn't seem to be, even though helmets were available, and sustained a fairly bad injury. Now, he sued Strutt and Parker, alleging he was at work at the time. Now, the purpose of that taking that line of argument was really to draw in the duties incumbent upon Strutt and Parker under the Health and Safety at Work Act, in terms of Section 52. The applicability of the regulations flowing out of that Act only apply if you're at work. Now, for example, the PPE regulations and, for example, in this case, the necessity to wear a helmet. However, none of those had any application unless he was at work. Now, if we could have the next slide, please. You'll see the quote I've put on the slide. It's a fairly lengthy quote, and that's part of the judge's rationale. And he seems to be very much of the view in that case that, look, this was not, inverted commas, at work. The fact it occurred as it did in the circumstances, as he puts it, where the claimant was enjoying the defendant's hospitality, seems to offend a sense of justice and and reasonableness to conclude that the Health and Safety at Work Act and the regulations were ever intended to be used in those type of circumstances. That strikes me as approaching the case on quite a narrow premise, that an away day is clearly not an example of acting in the course of the employment, nor did the judge seem to think that what the claimant was doing was reasonably incidental to his employment. I wonder what his view would have been had this been a case where the claimant had been injured in a work five-a-side football match against clients. Would that have been incidental to his employment? And if so, are we really splitting hairs to say that an away day is any different to that? Notwithstanding the fact that the judge didn't see any merit in the claim under statute, the claim did succeed at common law because the risk assessment undertaken by the defenders was deficient and indirectly causative of the injuries. Those carrying out were I think it was the managing director and the senior partner of the chartered surveyors firm, and unsurprisingly, the court held that they weren't qualified to do that and failed to recognise that the need for helmets when cycling and the associated HSE guidance on this point. It held that the failure to properly risk assess had been indirectly causative of the injury, and that applied the rationale from the urine against corporate leisure UK case, which is another well-known sports injury case going back a little further. Had an appropriate risk assessment effectively been carried out, the most significant risk of injury, i.e. a collision, would have been identified. However, given in that case the claimant's responsibility for the collision, he had to accept a greater proportion of the blame, and a portion of the liability was 2/3, 1/3 in the defender's favour, which is not a bad result for the defenders. If you're going to go down for something, what they got out of it wasn't as bad as it could have been, perhaps. Now, the point here is the judgment in Reynolds has been criticised. I don't think certain authorities were placed before the court, and the judge's reasoning really is a work away day, an extraordinary incident. It's been said with the benefit of hindsight, is that really the case? Are these events now not commonplace? Or they were up until COVID happened. And if that's so, and if the reality is that the employee doesn't really have much of a say in whether to attend, should they not be viewed as falling either within the course of the employment, or if it doesn't amount to that, at least incidental to the person's employment? And thus, should that person not be afforded the protection under the regulations made under the Health and Safety at Work Act? There's an argument on that, which is one of the issues which arose in the Grant case. So if I could have the next slide. So Grant against Fife Council, and it's again the other party is the Ministry of Defence. Now this is a Scottish authority. It's an outer house authority from the Court of Session. So it's not binding in any case any other Court of Session judge going forward, but it arises from an incident a fall from a set of monkey bars of all things. It didn't go to trial. This judgment arises out of a legal debate on the sufficiency of the pursuer's pleadings. Effectively, the defenders were seeking dismissal or a strikeout of the claim. Now, that failed, and a proof of trial was allowed, but some of the comments in the judgment are of interest, particularly against the backdrop of Reynolds from a couple of years before. In particular, the Lord Ordinary in Grant was unimpressed with the reasoning in Reynolds on the point of whether a statutory case should have been dismissed on the basis that it didn't arise out of the pursuer's or claimant's employment. He wasn't prepared to follow Reynolds on that, commenting really the distinction between ordinary incidents and extraordinary incidents or activities wasn't based on any authority. That seems to have just come into the judge's head and wasn't prepared to follow it on that basis, when in fact what the authorities did suggest is that whether something is in fact in the course of your employment, really that's an issue to be determined at proof or trial when the full facts and circumstances have been established. So he allowed both the statutory case and the parallel common law case to go to proof, commenting that Reynolds did support the view that a common law remedy might be available against an employer in the capacity as organisers of the team building away days or events, and how they had organised or reviewed these. So there's a couple of competing cases. I think the case laws could best be described as murky. So with that said, if I could have the next slide. So having heard what can go wrong in the legal wrangling that can follow, and to avoid having esoteric arguments that are now undoubtedly going to be expensive by solicitors arguing about what do we mean by in the course of employment, and what would you think would be reasonably incidental to the employment, how can you effectively improve claims defensibility and what mitigations can be put in place before it even crosses your desk? So this is work that can be done with the insureds and with your customers effectively. You'll see the slide makes some suggestions. I think some of these might be common sense, some of these might need a wee bit more thought. Firstly, I would say it's fundamental to make it plain to people that if it is voluntary, then it is voluntary, so that what you don't have is arguments that there's a culture of compliance and people feeling compelled to go and take part, otherwise it will be held against them. If you've got clear and unambiguous wording distributed to employees in advance, that should hopefully aid in rebutting arguments that employees have felt they had no choice to take part in activities under which they were uncomfortable or they didn't want to. I think secondly, it's important to be aware or cognizant of the characteristics and composition of your workforce. Clearly, rock climbing, assault courses, tough mudder, things like that might be more problematic for the vertically challenged or the aged and infirm. So bearing issues like that in mind when determining events and in assessing the risks posed by those events to your employees is going to be pretty important in the mitigation of any claims to follow, and in demonstrating as an employer that you've taken reasonable care when you're organising what should be a fun day out for your workforce. And thirdly, assess the risk and provide information to those attending in advance. I would suggest not to fall into the trap of Reynolds, of having chartered surveyors attempting to risk assess health and safety issues at an away day involving cycling and other events. I would suggest considering using an events management company to spread the risk and have them organise the event. Now, that would make prudent business sense, particularly for larger employers. And if the planning and organisation has been put over into the hands of a competent third party, then the duties or risk to the employer is going to be dampened or tempered to some degree, with the focus being on reviewing the plans made by the competent third party as an employer taking reasonable care to check whether they cut the mustard or not. Now, that brings me to my fourth point of imparting clear and sufficient information in advance to employees. It's important, I would say, to tell them what the events are going to involve, the risks involved in those, what safety measures are in place, and the instructions or information that's going to be provided at the point of service at the event itself. And fifthly, and this might seem like a fairly obvious point, if the day is to involve alcohol, and I'm fully aware that people being inebriated is sometimes the only way to get through certain events, I would say at least to keep the natives off the booze, at least until the activities which could see them lose any limbs or injure themselves are over. It seems to me to be better to lose your dignity in the bar than an eye participating in archery, particularly if you're wrapped in the warm embrace of Mrs. Stella Artois, which is probably not going to end well, particularly if you've got a bow and arrow. The final point I wanted to flag up before we conclude today was really of that of policy wordings, and they need to check those quite carefully for brokers, underwriters and insurers, and particularly given the lack of conclusive case law on whether away days do fall within the scope of employment at work or not. Important, I would say, to carefully review those policies are written to whether they either expressly include or exclude such risks, to avoid coverage disputes with your insurers in the event of a claim being made and it then coming to pass that there's a lacuna in the policy wording, whether either deliberate conduct, reckless conduct or away day claims just haven't been thought about at the point of policy inception. So I've gone 2 minutes over, which isn't bad for me. So that's me. That's a trot through corporate away day claims gone wrong and sports claims and some issues to consider. So I'm happy to field any reasonably easy questions if anybody has any, or if not, I would bid you all good afternoon. But I'm happy to stay on for a few minutes if anybody's got any queries or any points or anything I've got demonstrably wrong in the last half hour. I take silence is golden, so I'm going to take from the silence at the other end of the line, or other end of the ether on the screen, that nobody has any questions. If you do have any queries and you don't want to articulate them over the medium of the internet, please do feel free to drop me a line, either by email or on the phone. I'm happy to field any queries. And if not, listen, it's been a pleasure speaking to you all this afternoon, as a guest myself to this event. And thanks very much, and I bid you a good afternoon.